Thank you, everyone, for joining us this evening, and we're going to welcome Terry Dougherty back again, who is fortunately presenting for us. Thank you, Terry. I'll go ahead and introduce you, and then we'll let you get started. Terry Dougherty has held multiple positions working for the National Park Service, the Army Museum System as acting director, and now the Spotsylvania County Museum as curator. During his time as acting director of Army Museums, he was responsible for the administration of 59 museums. As curator for Spotsylvania County Museum, he has completed 2 major exhibits, coordinated and assisted with 150th anniversary local events, oversaw building renovations, and design of the new museum location and website. All right. And I will let you take it away. Talk about your presentation this evening.
Okay, thank you very much. First off, as she said, we'd love to welcome you to another in the series of the 300th lectures on the history of Spotsylvania County. Tonight, we're going to take a little bit of turn. We're going to turn away from the historical timeline on the formation of the county, and we're going to talk about events that unfolded here in the early 1900s. And so tonight's program's entitled Dastardly Deeds, High Crimes in Spotsylvania. And we're going to look at 3 cases involving the local citizens who were charged with murder, and take a look at how those cases unfolded and the events surrounding them. And we hope you really enjoy it. So we're going to get started. The first case we're going to talk about tonight is the case involving Nelson v. Carter. Now, you're looking at a photograph that I entitled A Happier Time. And what it was this photograph, I believe, was taken probably around 1901. And you see the Carter family. The Carter family lived out near Broken Borough, which today is on the road to Lake Anna. And you can see little Broken Borough Road there. It cuts off of 208 and goes back and circles around and comes back. So that was a local little community. And there were literally hundreds of them in Spotsylvania County at that particular time. And so the trial of Nelson Carter for the murder of his wife, Hattie, was one of the most sensational cases at that point in the history of Spotsylvania County. Now, as I say, this photograph was taken in a happier time. And so amongst the members of the family here is in the center with the long Van Dyke beard is Festus Carter. That is Nelson's father. He was a veteran of the Civil War. He'd been wounded at the Battle of Cold Harbor, which is, of course, down south of us in 1864. Nelson is actually seated to his right. And as you can see, he's a rather tall, gangly individual. And directly to his back right, holding a small child, is his wife, Hattie. And so this photograph, like I said, was taken about 1901. And so as you can see, the family, looks reasonably happy, and everything looked fine. However, Nelson was a very interesting individual. He was apparently, according to the neighbors, he was a very angry man, and he was extremely jealous. He married Hattie in 1891, and they had 5 children. They were all girls, interestingly enough, and he worked as a laborer, doing various jobs here in the county to make a living for his family. And as I said, he was apparently a very, very angry man. He was also a very jealous man. And he firmly was convinced that Hattie was having an affair. And as sometimes you get in discussions with individuals, how a woman with 5 children can have time to have an affair is probably, a reason to question things. But nevertheless, he firmly believed it. And so on the evening of February the 6th, or the afternoon, it was a typical February day. The weather was fairly clear. He returned home, and Hattie had filed for divorce, the classic case of the angry husband. He had counterfiled for divorce. but apparently divorce was not on his mind that afternoon. He walked into the house, produced a pistol, and proceeded to shoot her. Well, the shot, of course, didn't knock her down. In fact, she was able to escape, run out the front door, and start into the yard. And he followed her, and he shot her an additional 4 times in the back. The final shot hitting her spinal column, and that killed her instantly. He later claimed she was reaching for a gun, but that explanation actually didn't make any sense because she didn't own a gun. And so basically the neighbors gathered in the yard, and the sheriff showed up, and he found Nelson sitting in the living room of the house with 2 of the children, and proceeded to arrest him. And so the word of what happened spread rapidly, and the local papers picked it up, not only in the Fredericksburg area, but also as far away as Danville, Virginia, and Richmond. And so the case gained prominent attention, regional and later on national attention. So Carter was indicted by the grand jury, and he entered a plea for insanity, or homicidal mania, as it was known back then. So I'm going to switch sides right here. Yeah. Let's see. Excuse me, having a little technical difficulty right there. Take it back up. There we go. Okay, I'm sorry about that. So anyway, as you can see in a close-up photograph, the person sitting on the ground in the background is a person by the name of Monica Lewis, and her family contributed this photograph. And this was her death certificate as it was filed at the time. Murder, shot by husband, 5 bullets in the body. And so Nelson was indicted before a grand jury. They described the weapon as having the capability to fire 6 rounds, and but as later noted, and it became one of the trial errors, the weapon was only capable of shooting 5 rounds, and it was valued at about $5 by the people involved in the case. So the case proceeded into the hands of Judge Robert Henry Moncure Chichester. He was born in Fairfax County, and he had been a veteran attorney, and now was entering his 5th year on the bench. And the Commonwealth attorney for the Commonwealth was Spotsylvania T. Stokely Coleman, a gentleman who would hold that position off and on for almost 40 years. And so he was the primary prosecutor in the case. The defense attorneys, usually when a case like this is held, because needless to say, Mr. Carter was not a rich man. However, in this particular instance, the defense attorneys both were from Fredericksburg. One was Alvin Thomas Embry. And of course, Thomas Embry was a local attorney at the time. Later on, he would also be a judge, just like his father. And of course, Embry Dam is named for the family, the famous Embry Dam that was removed several years ago. The other attorney for the defense was Frederick Coleman. Frederick Coleman was a Spotsylvania County citizen, and he took the case in an effort, to provide a proper defense for Mr. Carter. And these were the people, the primary prosecutors and defendants in the case. Now, what happened at this time was the trial began on February the 28th, and it would continue for 4 days. As I said previously, Nelson entered a plea for homicidal mania, and over 100 witnesses were called during this case. And amongst the witnesses were Nelson's father, Festus, at this time, in his 80s, rather feeble, had to be assisted to the jury chair during the trial. And he talked about Nelson and the fact that he had a bad temper. He said he'd been struck as a boy in the head with a stick and had not been quite right since that point in time. And also testifying was Mr. Carter's 3 oldest daughters. And they all testified for the prosecution, not the defense. Hattie Childress, married at the time, the oldest daughter, testified that she'd seen her father beat her mother many times, would spit in her face, threaten to blow her brains out, and that when her father beat her, referring to Hattie herself, her mother would try to defend her and then be beaten herself. And then Eunice Carter, one of the other daughters, also testified that her father would beat her and that she had once witnessed her father strike her mother with a rolling pin and would never like to go anywhere outside of the home, being afraid that, something would happen to her. Fossey, the other daughter, testified that her own father had threatened her life and she was forced to leave home. She also said she once witnessed her father whip her mother with a bunch of birch switches. And court testimony revealed that shortly after killing his wife, Carter said, I don't want to be buried within a half a mile of that expletive deleted. I don't want to be buried near that thing. He firmly believed that she was having an affair, but all the witnesses out of those 100 witnesses that testified to her character in court said she was not. During the trial, Carter was rambunctious, to say the least. The court, Judge Embry, had difficulty keeping him quiet. He had to be restrained on numerous occasions. And but most of the witnesses out of these 100 witnesses that were called who testified on Carter's behalf talked about insanity and mental health issues running in the family. Despite all of that, the case was presented to the jury on March the 3rd at 9:10 p.m. It took the jury less than 20 minutes to return a verdict, and the verdict was guilty, and Vernon Carter was sentenced to death by electrocution at the federal penitentiary in Richmond. And so now the interesting thing about this was, as part of the verdict, executions in Virginia had been normally carried out by hanging for almost 300 years until the first electrocution in 1908. So this was a reasonably new approach to dealing out capital punishment, and it fascinated the local populace. And so the case was appealed to the Virginia Supreme Court, as to be expected. And the court denied the appeal. And then Nelson Carter, of course, was sent to the electric chair and executed in the presence of witnesses from Spotsylvania County who could testify to the fact that he had been put to death. And the photograph on the left-hand side of the slideshow is a photograph of the original electric chair that was used at the Virginia State Penitentiary to carry out executions until the penitentiary was closed in the late 1970s. And so on the right-hand side is his death certificate, and it says death by electrocution. And so the case came to an end, and life in Broken Borough on the edge of Spotsylvania County began to return to normal, or as normal as it could be after such a horrendous incident. So the second case we're going to look at this evening is the case of Robert Powell, Dr. Robert L. Powell. Now, this case was really quite interesting because of all the individuals involved in it. And what you have here is an interesting individual himself. Dr. Powell was born in August of 1886, and he was born here in Virginia at Plentiful Farm. And the Powell family had lived in Spotsylvania basically since the late 1700s. And he was a doctor by profession. He attended medical college, George Washington University School of Medicine. He also attended Columbia University medical department. He graduated in 1909. And he had his medical degree was in a term that a lot of us may not be familiar with. It was called an allopath practice specialties, which basically means a doctor of all trades. And of course, he plied his trade in the Belmont area of Spotsylvania. On the right-hand side is the obelisk monument that was erected after his death by the words on the monument by a group of citizens who really appreciated his character and confidence and the services he provided. And so that monument still exists today out off of a Granite Springs Road in Spotsylvania County. So basically, what happened here was Dr. Powell let me go back up one. Dr. Powell entered into an altercation with a gentleman known as Charles B. Kendall. Now, Mr. Kendall was a local farmer who lived out in the Granite Springs area of Spotsylvania County. And this basically shooting, and that's exactly what happened, happened because of apparently a long-standing feud between Dr. Powell and Mr. Kendall. And also involved in this were all of Charles Kendall's sisters, okay? And so anyways, after all of this happened, moved over into Orange County and operated a furniture and hardware store, which is still there today. The altercation apparently occurred as a result of Dr. Powell's dealings with the Kendall sisters. Okay, and Dr. Powell was accused of basically of ungentlemanly acts towards the sisters. When one of the sisters went to see him because she was pregnant, then what Dr. Powell said was, okay, I can recommend a place for you. Now, this is according to witness testimony. I can recommend a place for you to go and have it taken care of. Now, at that time, abortion within the regular populace was not something that was often discussed. Okay, if anything, if the mother was unwed, she might be sent with relatives somewhere out of the area to have the child and then return later on. But in this particular case, Mr. Kendall took offense with this, and he also took offense at the alleged advances by Dr. Powell towards his sisters. Now, Dr. Powell was a rather large man. He was well over 6 foot tall in the previous altercation. And when it was over with, Mr. Kendall swore up and down, basically, that you would never do this to me again, and etc. And so what happened was Dr. Powell went to Doolin's store, and there he encountered Mr. Kendall. And he came into the store. The two gentlemen spoke briefly, and then they said, well, let's talk outside. And so when they started outside, Mr. Kendall produced a pistol, and Dr. Powell backed away, and Mr. Kendall fired one round, and the round struck Dr. Powell in the arm. Dr. Powell turned, according to the witnesses, and tried to make his way to his vehicle with Mr. Kendall pistol in hand, continuing to fire. He fired a total of 4 shots. At one point, one of the shots, and nobody could say whether it was the second, the third, or the fourth shot, struck Mr. Powell and killed him on the spot. And, well, mortally wounded him. He died about an hour later, but for all intents and purposes. And so that was the victim. Of course, Mr. Kendall was immediately charged with murder in the first degree and held in the Spotsylvania County Jail without bond until his trial. As in previous cases concerning the Commonwealth, in this particular instance, the judge of record at that time in Spotsylvania County was still Robert Henry Moncure Chichester. However, he had accepted a special assignment with the Virginia court system to serve on an appeal court. And now, whether or not that was arranged because of the knowledge of the defendant and the victim, or whether, actually he was really needed that badly, he precluded himself from the case. The second person involved in this was the Spotsylvania Commonwealth attorney, one gentleman by the name of Peter Powell. And guess what? Peter Powell was the brother of Robert Powell. And Peter was well known in the political circles and the circles of the Spotsylvania court system as a man with a temper. He had once engaged in fisticuffs with a lawyer from Fredericksburg on the courthouse lawn at Spotsylvania Courthouse. And so he was also reclused from the case and basically, as the saying goes, had to sit this one out and watch the accused killer of his brother being tried. Instead, what the court did was they took Archibald D. Dabney. He's pictured on the lower right here. He was a juror from Charlottesville, and he was appointed to handle the case. Additionally, C. O'Connor Gulrick, of course, the Gulrick family in Fredericksburg, his father was a judge as well. He accepted the case and took the appointment as a temporary prosecuting attorney for Spotsylvania County. And so those were the two gentlemen that would be in charge of prosecuting the case against Charles Kendall. Okay. And so for the defense, Mr. Kendall was able to hire a local attorney. William Walker Butzner agreed to take the case. He was well known in the county, handled many cases in the Spotsylvania County court system. He was a general purpose lawyer, handled everything from civil to criminal. He served on, and many times as an appointee of the court to handle tax sales of property. So he was well known and well liked. The second attorney was from Richmond. His name was L.O. Windenberg. And Mr. Windenberg was a specialist in dealing with cases involving murder and the potential for the death penalty. And so Mr. Kendall had in terms of his own defense, had an excellent defensive team assembled. The accused, Charles Broadwin Kendall, at the time of the incident, he was 23 years old. And what was not brought out in the trial, which I found very, very interesting, was he was a veteran of World War I. On the 1920 census for Spotsylvania County, he was listed as an Army cook. However, there might have been a little bit more to it than that, because when we look at his military record, okay, what we discovered was he was a draftee, and he ended up assigned to the 104th Infantry Division, 104th Infantry Regiment, of the 26th Infantry Division, which is known as the Yankee Division. They were from New England, and they went overseas. His name does show up on the passenger manifest list of troops, and went overseas, and basically he saw the elephant. He was in the Meuse-Argonne offensive. He was in St. Michiel. Everything, 6 major engagements that the 104th Infantry Division fought in, he was a part of. And so that part of the story was never was never brought out in the trial, the fact that he was a World War I veteran. And as life would turn out later on, he would join the Navy at the start of World War II and become a Navy veteran as well. And his tombstone reflects his naval rank of seaman at his burial location. So Doolin's store was the crime scene. Doolin's store is if you look at the map on the left-hand side, it says Granite Springs. That's where it was located. It was right on the Orange County line, just above Pannier, which was another community. And, you know, it was a very small community, maybe 150, 200 residents at the time. And Doolin's store was a rental property that was operated by James Lewis Doolin. And Doolin was assisted by his wife, Myrtle. And the photograph on the right-hand side is Daisy Eustace and Myrtle Eustace Doolin. So Daisy and Myrtle are sisters, and they would figure prominently in the case. As court testimony brought out, Daisy was the one that invited Dr. Powell to the store that evening for the meeting. And that was at Myrtle's request. She knew of the problems between the two and, arranged a meeting to sort of calm things down. Of course, things did not calm down because the altercation occurred and the incident happened. Now, the incident, there was witnesses to the incident. One of the witnesses was with Charles Kendall. His name was Arthur Raines. And before the trial ever took place, he was charged. He was 32 years old. And at the time, he was under a $1,000 bond as a material witness in the case. And strangely enough, according to the family and family notes, he was concerned that he was also, as a result of this, because he had accompanied Mr. Kendall up to Doolin's store that evening, that he would be charged in the case as well. And this was a gentleman with a wife and 6 children, but so overcome with fear that he actually, in the presence of family members, pulled out a shotgun and shot himself. And thus, one of the material witnesses to the case never made it to the case. It was a tragic, tragic death. A classic example of perhaps someone, that was either mentally disturbed or just so overcome with the situation that he simply couldn't handle it. And so what we have here, this is the newspaper report on the left-hand side that stated the witness is a suicide. And of course, that got people to talking. And then the certificate of death, which shows that it was by his own hand that was signed. Now, the next thing, of course, that happened was we had the trial itself. The trial started on August the 19th after numerous delays. Now, you can remember the crime occurred in May. And what happened now, Judge Dabney is in charge of the case. And so initially there was a panel of 50 jurors selected from county residents by the Spotsylvania Clerk of Court. That's what he does. But the jury pool was increased by an additional 46 members by Judge Dabney. I think he was concerned as to whether or not Mr. Kendall could probably get a fair trial. In the end, but as you're aware, that in any case, both the prosecution and defense had the opportunity to strike potential jurors. And so everybody used up all their strikes. And in the end, 4 jurors turned out to be from Spotsylvania. 6 of the jurors were from Charlottesville or the Charlottesville area. And there were 2 jurors from Fredericksburg. And also on this, of course, are part of the witnesses. Sister Roberta Kendall Taylor on the left-hand side. And this was from a courtroom sketch done at the time of the trial. His aged mother, who, when she testified during the trial, what she basically said was, I told my daughters to stay away from Dr. Powell, and they would not listen to me. And so I told my son about it in an effort to protect them. Now, she made quite an imposing witness in this case because when she was very feeble, and when she took to the stand, she wore all black with a black veil. And it wasn't until this veil was revealed that her face, lit up in the sunshine coming through the windows of the courthouse. And so she gave this very striking appearance, according to the people who were there, and talking about the case. The other person was Julia Kendall. Now, Julia Kendall, of course, is the one that Dr. Powell allegedly made improper advances to. And so the case actually dragged on for a number of days. And some of the testimony in the case is really very, very interesting because we actually have the actual court testimony because the newspaper reported on it in great detail. And, basically what the prosecution tried to establish was that the real motive behind Kendall's shooting of Dr. Powell was none other than Myrtle Doolin. There were rumored whispers in the neighborhood of an affair between Myrtle and Charles Kendall. And also rumored in the neighborhood was Dr. Powell also had a special affection for Myrtle. And so Myrtle found herself at the center of the controversy in this case. In fact, when it came time for her to testify, and when Julia Kendall testified, in one instance, the courtroom was cleared. Only the jury, including the jury, and only the judge and the defense and prosecution heard her testimony. In the second instance, the jury, the panel was cleared of everyone dealing with Julia that was below the age of 16 years old. And amongst the questions, the prosecution, like I said, attempting to prove their case, was trying to prove that he was really trying to protect his own interest in Myrtle and not those of his sister. So the case went back and forth, with the prosecution viciously attacking and cross-examine all the individuals involved. And of course, at some point, the defense made a determination that they would put Charles Kendall on the stand so he could defend himself. Now, that is only something that is done usually by courtroom attorneys when they feel the case is in doubt. And so in this particular instance, Kendall took the stand. Now, the newspapers described him as a red-cheeked youth with a youthful appearance and an air of fearless innocence, because during the entire trial, he spent most of the time with his head resting on his hand, his left hand, and he just simply watched everything. He did not show any sort of emotions. He did not smile. He did not laugh. He just basically took it in. And one must wonder if all of that service in World War I and the combat, even as an Army cook being under shell fire in the trenches of World War I, had a little bit to do with his countenance and the way that he handled himself, because everybody commented about it. Now, hundreds of the farmers and the farmers' wives from all over had gathered at the courthouse on this particular day. So many that the building was filled, and so many were turned away that they all stood outside the courthouse and basically waited to hear the testimony. And in the testimony, he was asked, basically, did you hug and kiss Myrtle Doolin? He said, yes, I did. Another witness testified that they had gone upstairs on the store and turned the lights out for 2 hours. Another witness said it was only 20 minutes they were upstairs with the lights out. And the clerk working the store, of course, he was inside the store. He didn't know whether the lights were turned out upstairs or not. and his testimony reflected that. So in the end, he said, I shot him in self-defense. He basically had beat me, and I feared for my life. And so when he ran for the car, I thought he was going for a gun. And that is the reason I continued to fire. And with that, the case was, Judge Dabney sent the case to the jury for determination. Now, what happened at this particular point, needless to say, the Powell family, especially Peter, was well known in Spotsylvania. And, a lot of people would call him a whippersnapper. And so one of the things that everybody thought unusual, the judge admonished the courtroom that when the verdict was reached, he did not want to hear a word. Anybody that outcried or made any attempts within the courtroom would be charged with contempt. And so 70 minutes later, after hearing all the testimony, all the innuations, everything else, the jury returned. And they acquitted Charles Kendall. And now, everyone was surprised, but apparently there were no outbursts. Kendall showed absolutely no emotion when the verdict was read. And about an hour later, he walked from the courtroom a free man. And he told the reporters outside, I'm going back to the farm and I'm going to and get on with life, basically. And that's exactly what he did. And there was no retribution, although I'm sure there may have been discussion of it. But he had been tried by a jury of his peers and acquitted. But, karma is a funny thing. And so Charles Kendall, after all he'd been through, a World War I veteran, a World War II veteran, the trenches, a murder trial, did not live a full life. In fact, unfortunately for him, is in 1946, he was killed in a farming accident. And the death certificate, which is on the right-hand side of this particular slide, states that he was either struck by a pole or a tree and killed instantly. So, and that happened in a farming accident somewhere out in the community of Spotsylvania County. And he was only 46 years old, and he lies buried at Mount Hermon Baptist Church Cemetery in Spotsylvania today. Now, the third case that we're going to look at is the one that was sensationalized. If we thought the other two garnered attention, this particular case would garner not only statewide, but national attention. The headlines of the Freelance Star from April the 2nd, 1935, pretty much told the story. 2 murdered in Spotsylvania, both bodies thrown down the well. And in this particular instance, the crime scene was the farm at Hickory Point. Okay, Hickory Point Farm. At the time, it was owned by J.T. Coleman, and he lived there with his wife, Jenny. And they were both elderly. He was a lifelong resident of the county. Interestingly enough, he was widowed. And at the time, before their marriage, so was Jenny. And these two found each other late in life, and they were married. Jenny was had originally married a railroad contractor by the name of Ernest Carpenter in 1904, and they moved to South Carolina. And unfortunately, Ernest was working to get employees from the campsite to the work site at the railroad when he was mortally wounded, shot by the foreman of Carpenter's company, D.C. Purdue, who apparently had a grudge against him. So her first husband had actually died at the hands of another man. And so, but these two had found each other late in life. And so they lived out there, and and operated a farm, and as most people did in rural Spotsylvania. And the photograph, the farmhouse is of course where the incident occurred. Now the funeral, they had joint services. John Coleman, he'd been born in 1858, so you can tell he was very elderly. And Mildred had been born in 1870, so there was an age difference. However, when it came time for the funeral, they were buried at separate sites. He was buried on the home place, and Jenny was buried at her former home in Chancellor. So, and Hickory Point, just for a matter of reference, is located between Spotsylvania Courthouse and Thornburg off of Massaponax Church Road. And so basically what happened in this particular case was a worker who was hired by Mr. Coleman came to the house the morning of April the 2nd and noticed that, he asked for Mr. Coleman, reported up to the house to get his day's assignments. And Mr. Coleman didn't answer him. And he noticed that the door of the house was open. Well, he didn't go in the house. Instead, he looked around. He tried to find Mr. Coleman or Jenny. He couldn't find either one of them. So he went down the road to Mr. Coleman's cousin's house, Oscar Scott, and said, "I can't find the Colemans. I think something's happened up there." And so he and Scott returned to the scene. And at that point, they noticed that the family automobile was missing from the garage. And so fearing foul play, they contacted the sheriff, who at the time was Sheriff Blades, M.L. Blades, and Mr. Blades came out. And what they discovered was the family dog was on the front porch. And the dog would keep leaving the front porch and walk out towards the well in the backyard. And so finally, they went out to the well, looked down inside the well, and discovered that, well, there's something down in the well. And then they called for additional assistance. And what they discovered was both John Thomas and Jenny's bodies were in the well. And so the bodies were retrieved. And you'll notice that the death certificates, which are shown here for each and every, for both individuals, indicated that they were both shot and that the bodies had numerous wounds to them, to the head and to the scalp area, which gave the indication not only were they shot, but they had been beaten. And basically the bodies had been disposed of in the well. And so this case, once again, electrified everyone when the headlines of the Freelance Star hit the press. And so the case began immediately. Now, the crime had happened, of course, on April the 2nd. And so they immediately went searching for witnesses, for anybody who had seen the car. Well, the gentleman in question filled the car up with gas down near Thornburg. And so someone asked one of the representatives, did you see the guys who were driving this? Can you describe them? And he said, yes, they were two black men. I think one of them was. Well, that turned out to be a false lead. They spent about a week attempting to locate and question a person that in the end had not been involved with the crime whatsoever. So the search continued. The car was located in Richmond, outside a Japanese restaurant, and of course they went in. They found out that they were two individuals. They were known not by name, but they were known to frequent the Japanese restaurant. In fact, on the night of April the 1st, they had both been in the restaurant, not once, but twice. And so they left the car and then proceeded onward. A few days later, one of the individuals, a gentleman by the name, and I want to make sure I get him correctly in order, um, John Shell, um, actually turned himself in. He heard that there'd been a reward posted, and so he turned himself in and said, "Yes, I'm familiar with what happened, but I did not do it." Well, if you didn't do it, who did do it? And so, on that particular instance, what they found out was that the other person, a gentleman by the name of Joe Jackson, is who he indicated was the person in question. And what happened was they immediately started a search for Mr. Jackson, and they actually traced him to New York City, where he had gone with his wife. He had 2 children, and they discovered him in a rooming house in New York. And when they went in to question him, accompanied by New York detectives, there on the dresser was a gold watch that was later identified as belonging to John Coleman. So accordingly, they were both charged with murder and remanded in this particular instance because of the apparent gruesomeness of the crime. They were not held in Spotsylvania County. They, in turn, until their trial, was held in Henrico County for fears that the populace would be stirred up. So, in this particular instance, let me back up one. The Commonwealth. The judge for this particular case was Judge Frederick Coleman. Now, you remember Mr. Coleman had been the defense attorney for Vernon Carter. His career had advanced until he had received an appointment as a judge. And the prosecuting attorney for Spotsylvania County was Emmett Roy Carner, well known, elected to the position, well thought of in the community, also a lawyer in past time. And, he was the gentleman who would prosecute the case. For the defense for the 2 individuals charged, one was Harry Sager. He was a well-known local attorney, well-respected, well thought of. He was from Fredericksburg. He was appointed by Judge Coleman to take the case. Now, this is a classic example of if you do not have an attorney and cannot afford one will be appointed for you. That's pretty commonplace in Virginia law. And so Mr. Sager took the case. A second attorney, E.A. Norrell, a black attorney from Richmond, would take the case after the verdict was returned. And we'll get into that a little bit later on as the conditions and everything surrounding that. So the accused, Joe Jackson and John Shell. Okay, so what happened was during the court case, which lasted about an hour, Sheriff Blades presented the evidence that he had found. Of course, the local Richmond papers were covering this in detail. They had a photograph of the Coleman's abandoned car in Richmond. Excellent submission to evidence. They had a photograph of the Japanese restaurant where they had eaten. And of course, probably the only witness to the case could not testify. The actual eyewitness to the case, the family dog, he could only wonder what had happened to his owners that evening. Of course, as I've already related, he led them to the well in the end. And of course, the other thing, which of course was really considered to be solid evidence, was the gold watch. Now, this is not John Coleman's gold watch, but it's a watch of the time frame. And so that watch, more than anything else, would lead the prosecution to presenting a very strong case. So the trial, once again, the trial was held in Spotsylvania County. The prisoners were brought from Richmond. They were under not Spotsylvania County Sheriff's Department, but instead they were actually under the caretaking of the Virginia State Police. And when they brought them up here, they must have sensed that maybe something might not go well. because they were armed to the teeth. They were carrying Thompson submachine guns, pistols, tear gas, and riot mask and billet clubs. And sure enough, when the prisoners were being led from the jail where they were temporarily housed into the courtroom, they were attacked by citizens from Spotsylvania County. The two men in question were the Foster brothers, who pleaded with the crowd to help them. The crowd declined to do so, and they were beaten off with billet sticks, and everything continued with a large crowd milling around outside the courthouse to hear the case. So anyway, Mr. Sager, the attorney for the defense, basically had only met with the defendants that morning. Okay. And so he really didn't have a defense to mount. His remonstrations with the court was, if you believe the men and they say they didn't do it, then acquit them. Of course, what the men said was they blamed each other. And so as a result, the verdict was guilty, and both gentlemen were sentenced to the death penalty by electrocution at the Virginia State Penitentiary. And so the thing on the left-hand side is, to whom it may concern, I certify that the order of the Circuit Court of Spotsylvania, dated December 7, 1935, directing the electrocution on Monday, January 5th, was delayed by the governor. He gave him a reprieve. And the reason why was, of course, their new attorney, E.A. Norrell, felt that they had not been given a fair trial, that they had not been given the opportunity to make a strong defense of their innocence. This particular case, believe it or not, went through 5 appeals all the way to the Supreme Court of the United States. However, unlike today, when these appeals can take year after year after year, this was fairly quick. The Supreme Court declined to hear the case. And so on the morning of January the 2nd, 1936, both gentlemen were put to death by electrocution at the electric chair. And they were witnessed, of course, by citizens from Spotsylvania County to ensure that the verdict of the court was carried out. And so what really got the national attention on the case was Sheriff Blades himself. During that time frame, along with newspapers, magazines were a very important part of society, and especially magazines of true stories of the Old West. And in this particular instance, true crime. And this case was sensationalized in True Crime magazine in 1936, where Sheriff Blades, of course, who received credit accordingly, sensationalized the case, and the case was read throughout America, as to the dastardly deeds done with the bodies dumped down the well. And so if you ever pick up a copy of True Crime magazine from the 1930s, you just might find that case. Now, what's in the True Crime magazine? Nothing compared to the actual case whatsoever. But it certainly romanticized everything from murder to torture to, in the end, death. And so that concludes my programs tonight. I hope you enjoyed them. I know that was, as always, a lot of information, but, 3 really interesting cases of high crime in Spotsylvania.
All right. Thank you very much. And for folks watching, now's a good time. If you've got some questions, put them in the comments on our page, and we'll see how many we can get through.
I don't see this.
We do have one question that for the first case, that do you know if there any relation to the Powell's Furniture, the folks of Powell's Furniture?
I do not know. It is very possible. That's not one of the things that I looked at when I put this program together. So I can find out if you will contact me at the Spotsylvania County Museum, I can research that and and give you an appropriate answer.
All right. If anyone else has a comments, we've got plenty of time. We can go through them. I know that was a lot to cover with the cases, so thank you. Always interesting to find out what's happened in the past around here. Well, we'll just give it a few minutes. So I would say my question is, in coming across these cases, was there just anything that just really grabbed your attention to draw you to one of these cases?
I think the real thing that drew my attention was probably the case of Mr. Kendall. Like I said in my comments during the program, there was no mention of the fact that he was a World War I veteran. And so, but everyone talked about his charming innocence, boyish look, red, rosy cheeks. He did not look like, in the words of the newspaper, a killer. And but like I said, perhaps people did not know what the young man had already seen in life. If you've ever been in combat and under shell fire, especially during World War One, I know the 104th Infantry was severely gassed during the Meuse-Argonne offensive by German gas shells, and that's terror enough. Even if you weren't one of the unfortunate ones, just seeing the residual effects of what it did to your comrades. So, but yeah, that's the part that really interested me.
So we have a comment that kind of connects. It's for the same case. Did the gentleman who was a vet have any marks on him for joining the Navy?
There's no record of that, if there were any marks. The interesting thing is Tombstone does not mention his World War I service. His death certificate is whited out as normal. It says World War I and World War II on it. And so one of the things trying to search back to the records to find out exactly where he was at in World War II, I did not, with a short time frame I had to put this together, I was not able to determine exactly where he was at.
Thank you.
During his naval service.
Do we have any other questions, folks? Well, I guess, okay. Now we've got thanks from the Spotsylvania County for doing another great presentation. Thank you, Spotsy County. I was noticing with a lot of the cases, there was a lot of inter-county back and forth going on. Does that seem to be pretty common for all of the cases you've kind of gone through between Richmond and Fredericksburg and Spotsy?
Yes, as a matter of fact, when you have, of course, even today you have the lawyers who specialize when a case is going to involve the death penalty. And so it was not unusual at that point to seek assistance from the outside, from both sides, from both the prosecution side and the defense side. And so not unusual at all. And especially in the case of Mr. Kendall, because of the family, the Powell family, the fact that his brother was a Commonwealth attorney who had prosecuted large numbers of individuals in his short career. There was probably concern there about whether or not it could be a fair trial, one way or the other. Okay, whether you were for or against the situation that had happened. One of the things I did not bring out is later on the Powell, when he was Commonwealth attorney in 1930. His residence, which was located directly across from the courthouse, where today the parking lot of the Holbert building is, was burned to the ground. And he, of course, offered a $5,000 reward, believing it to be arson, but no one ever came forward with any information um, to to prove that theory. And right after that, Mr. Powell moved to Fredericksburg, where he would still engage in law. He was no longer a Commonwealth attorney for Spotsylvania, and continue his career at that point. And so, needless to say, the Powell family overall, um, at least in that short time frame there, did not fare well in terms of their personal fortune.
Well, thank you. All right. We can take any other questions now. If not, we'll wrap up shortly. Let me just give it a moment. All right. Well, I have a final question for you. I know from talking to you previously, you happen to like different ballads and things like that. And I know kind of in the time period, there are a lot of murder ballads. Do you know if there's any local ones that all have cropped up in relation to some of these older cases? Or did that seem to be more of a popular culture brought over from Ireland and some of the other spots?
That was more of a popular culture brought over from Ireland, but I know of no ballads. I know of no the ballad of the trial of Vernon Carter or anything like that. Although there's some really eloquent words written on Dr. Powell's tombstone out at Granite Springs. Um, I would call it a ballad. It was more of a tribute, and so anybody, the information's out there. I can give directions if somebody would like to visit it, and you can go out there and check it out. But it's allegedly erected at the spot where he was killed, so or in close proximity there. The store, the Granite Springs store, to my knowledge, is no longer there. Uh, so,
Okay. Well, thank you very much. Figured it was worth a try to see if we had any claim to fame.
okay.
Um, but all right, if that's all from everyone, we're going to wrap it up. Thank you again, Terry, for joining us this evening. And next time, folks, it will be with John Hennessy of the National Park Service. So stay tuned for that in April. And thanks very much.